Hey everyone, Harry here to talk about Attorney General James's response to Donald Trump's effort to simply wriggle out of having to post a $450 million or so bond in the civil fraud case where he was found to have, he and Trump Organization and others, executing a fraud scheme that cheated the people of New York out of that amount of money. Now, he's appealed, and you can appeal, and you don't have to post a bond to appeal. It's a little bit of a fine legal distinction. What you have to post a bond to do, and then within 30 days of the judgment, is to stay the execution, to keep A.G. James from, going around and attaching his assets and, if necessary, selling his real estate and the like. So he's got only a few days left to do this, and he parachutes into the appellate division where the case now sits on appeal and says, it's a practical impossibility for me to post this enormous bond, and attaches to it hundreds and hundreds of pages of different things, but the core document is an affidavit from a couple different people saying, we've been trying really hard and working with everyone, and we just can't do it. The only way that would even be possible would be because these meanie old, companies that post bonds are insisting on securities back, not real estate. So we'd have to have a fire sale of our glorious commercial real estate holdings, and that would be irreparable injury and unfair, etc. Okay, Trump does all these arguments in a reply brief. So he had filed a brief saying we shouldn't have to pay this. The Attorney General had then responded. He files a reply. Now, reply briefs are limited in their function. You're not supposed to do new arguments, offer new evidence. It's unfair to the other party, but you can respond to the things they say. So the A.G. James comes in and first has this. This is how it sort of works in the law. It's interesting. They have what's called a SIR reply, a reply to a reply. That's not provided for in the rules, but they write it all up, they submit it, and then there's a cover letter that says, you shouldn't consider Trump's arguments here because they were improperly made in a reply brief. However, if you do, we ask you, the court, and again, the appellate division, the Court of Appeals, because he pulled a fast one with all these new arguments and evidence at the reply stage, to consider a SIR reply on our part. Oh, and by the way, here it is. So if you grant it, continue to page 2 and you'll see our SIR reply. Okay. And so now we have their response. What is their response? First things is, it turns out these affidavits from a couple people are not from independent experts who have been helping, but people deep in the Trump camp who, the main one actually participated at trial as an expert, and his testimony was found by the court below, Justice Engoron, to lack credibility. So this is the guy they're hauling out in front to say, we're trying so hard, but we're not able to. And the same with the other guy, someone very, in the professional fold with Trump. So no credibility to the people who say they've been trying so hard. That's point 1. Point 2, says the state, is, in fact, it is possible to there are some companies that will consider real estate as security. It doesn't have to be. It's harder, and companies are, more wary of it. But there are some you can use real estate, like Chubb, that did it in the E. Jean Carroll case. Third, There's no reason that you have to have a single surety. You can have multiple sureties adding up to $500 million, and they apparently have not considered that. Fourth, there are $1 billion bonds that have to be posted. It happens in big cases. There's nothing, there's no practical impossibility to it. And fifth and finally, if at the end of the day, literally the only way to post a bond is to have to sell some real estate or collateralize it in some way, well, better that than leave the plaintiffs, people of New York, the Attorney General, at risk of not getting the money back. And, it's not said exactly, but it's probably implicit, with such a sort of recalcitrant and trick-pulling defendant as Trump. Oh, and finally, the motion that they're making is under a law that really should be used by its terms only to blunt a specific attempt at enforcement, say A.G. James going in and grabbing some property of Trump's in a way that they would allege is contrary to the legal command they've received. Instead, they're using it as sort of a blanket to seek out a blanket appellate protection about having to post the bond at all. So, pretty strong reply, especially this point about the ones who are promising it can't be done are just not credible. And moreover, they don't even seem to have tried this effort to do multiple bonds and the like. So appellate division, don't let him do it. And if the appellate division doesn't let him do it, and in short order, the judgment is out there, 30 days comes and goes, and Letitia James has a piece of paper that she can go to wreak havoc with Trump's New York holdings. So he's really up against it. We'll see what the appellate division now does, whether they accept the surreply. I would think they would. And B, will they just, as the surreply says, ignore Trump's arguments? No, probably not. They'll probably address them on the merits. But the AG has given some pretty strong reasons to say Trump's no different here. He's got to post it or face the consequences. So we'll see if that's what happens in pretty short order. Talk to you later. Thanks for tuning in. If you enjoyed this video and other Talking Feds content, please take a second to like and subscribe. Talk to you later.